Labor Commission Lunch series is something that we've done for almost 2 years now. We're working on 2 years. We started out working with the Occupational Safety and Health Division, particularly with the public sector consultation. And then we've moved on. This year, we are pleased to be able to have the directors from each of the Labor Commission divisions. And today is no exception to that. And previously, we had Tyler Whitaker from the Anti-Discrimination and Labor Division scheduled to be here, but unfortunately, he called me yesterday and said he's ill and not able to attend. However, fortunately, we have Shayla Slaymaker here with us today, and I'll give a quick introduction to Shayla, and then we will turn the time over to her. Shayla graduated summa cum laude from Southern Utah University as a criminal justice major in 2013. She then attended Creighton University School of Law, where she participated on multiple trial, moot court, and arbitration teams. Shayla graduated magna cum laude from law school in 2018. After graduating from law school, Shayla worked for Union Pacific in their equal opportunity employment department as an internal EEO investigator. She has been an employment and housing discrimination investigator with the Utah Anti-Discrimination and Labor Division for over 2 years, and now is a hearing officer for wage claim disputes filed with the division. We're really excited to have Shayla here to present to us today, and I know she's prepared for lots of questions, and I'm sure there will be plenty of those. She will present, and then we'll have a Q&A session after that, and after that we will break for lunch. Please join me in welcoming Shayla.
Thank you, everyone, for having me today. I appreciate it. Hopefully, is the PowerPoint ready to go? Okay, awesome. So just a notice, I guess, I cannot provide legal advice. So while I'm prepared for questions, if it is tending toward the legal advice, I do have to abstain from answering those. But hopefully I can help y'all out here. So first off, the mission of the Labor Commission is to achieve safety and fairness in employment and housing. So the Utah Anti-Discrimination and Labor Division has 3 units within it. So we have our wage claim unit, our fair housing unit, and our employment anti-discrimination unit. These used to be completely separate. Now our housing and employment investigators, it's kind of more one unit. The investigators will do both housing and employment. Our wage claim unit is separate though. So starting off with our wage claim unit, we enforce the Utah Payment of the Utah Minimum Wage Act, the Utah Employment of Minors Act, and Utah Administrative Code R610, which goes into further detail about what employers can do regarding wages. For the wage jurisdiction, it must be an employer-employee relationship. So that means it does not apply to independent contractors, but the designation that an employer gives an employee is not determinative. As you may know, many employers classify employees as independent contractors. They are actually employees. Multi-factor tests that to determine if someone is actually an employee, and what's most determinative in that is who has control. So for an independent contractor, usually they're going to be hired for a specific project, and they get to have control over how that project's done, when they show up to work, they buy the supplies, all of that. If the employer is the one doing all of that, controlling the schedule, supplies, controlling how, etc., they're more likely going to be considered an employee. So some exclusions. First off, agricultural, viticultural, or horticultural jobs, stock or poultry raising, and household domestic service. So if the employment is in one of these areas, we actually would not have jurisdiction. The acts don't apply, which is Interesting, but something to know. So, so Utah does have a minimum wage of $7.25 per all hours. Includes on the premises, ready to work, on duty, trainings, times that they're required to be in meetings, and normal rest and break periods. So not a lunch break, but those other breaks throughout the day should be paid. If an employer is going to change someone's rate of pay, they have to give advanced notice of that change. They cannot and change it and then retroact the employee. That would be a violation. And employers are actually record keeping for all of the time worked and wages paid, and they have to hold on to those records, I believe, at least 1 year. And now I'm blanking on the exact amount they have to hold on to those records. But if they're unable to prove that they have those records and the employee has those, we're going to base ours off of the employee's records instead, because they're the one with the proof. And it looks like there's maybe some audio issues online. Do you want me to pause so we can get those figured out? Keep going? Okay. All right. Yes. My understanding is that it should be actual hours worked. So that would be number of hours worked in a day. Am I swapping? Sorry.
So is a check all that for that record, or would you need like a description of the employee's, like a job description for that employee, and that is all that's needed, that and a payroll record? What are you talking about when you're
So
that record keeping?
Example, we've had cases before where all the employer has is a check stub that says they worked 40 hours this week, right? But the employee comes back and says, look, here are my time cards I submitted showing I worked more than 40 hours. The employer had nothing else besides that. So since the employee had a more detailed record, that's what had to base it off of. So I would say you likely want something more than just the check stub saying a total amount of hours. You're required to have a record of all time worked, and generally probably want something a little bit more detailed than just 80 hours over 2 weeks.
Shayla, you say that government employees aren't administered under the wage division for the wage unit. Is there another law and another government entity that does the same thing, but for government employers?
I am not positive. I'm not sure if, for example, the Federal Labor and Standards Act, I think is what it's called, FLSA. I'm not sure if that applies to government employees or not, because we don't administer that, but that would be my best guess.
Thank you.
Yep. Yep, no problem. All right. So for payment, employed at regular intervals, at minimum that should be semi-monthly, so twice monthly. Upon separation, payment should be paid. There's two different ways. If someone is terminated, so you fire an employee, they need to be paid within 24 hours. If the employee resigns, that can occur on the next regularly scheduled. There are penalties for late payment under Utah Code Section 34-28-9, which is 5% per day up to 20 days. So for mathematicians out there, that's 100%, meaning you would have to pay double the amount of wages if wages were up to 20 days late. All right, employers. So this is the Employment of Minors Act. What the jobs that minors may perform, and those jobs that they can perform vary based on their age. So it starts at 10 all the way up through 16 plus into that 16 to 18. Regardless of the age, minors cannot perform work in hazardous occupations. So hazardous occupations are going to be considered mining, logging, explosive meat processing, operating power-driven apparatuses or machines, things like that. So if there's a higher risk of injury, that's basically what's going to be considered your hazardous occupations. So for any age, minors home chores that are done for their parent or guardian. Sure. Tell it it's legal. So casual work, again, non-hazardous, and some agricultural work. At age 10, they can do things like deliver newspapers, shoe shining, some gardening and lawn care, but they cannot use power tools and caddying. And then 12 and above, they can keep in mind each of these includes what's underneath, right? So these are the additional jobs that they can also perform. So they can do sale and delivery of periodicals and merchandise, babysitting, and agricultural work, again, non-hazardous. At 14, you can also have things like retail food service, gas stations, janitorial, lawn care. They can do some power tools, and then non-hazardous areas in manufacturing, warehousing, and construction areas. So at 14, cannot do hazardous occupations, but they can work in those buildings as long as they are in a non-hazardous area. And then at 16, they can do any non-hazardous occupation, including driving a motor vehicle as long as they have a license. And then under the Utah Payment of Wages Act, there are retaliation. So employers cannot discharge, otherwise retaliate in the terms, privileges, or conditions of employment just because someone, what's the word? Sorry, I'm blanking. Exercise their rights under the wage acts. So if an employee says, hey, you didn't pay me correctly, and the employer thinks they're going to then file a claim, that's protected activity. The employer can fire that employee just because they're going to file a claim. If we find is retaliation, we can award payment of lost wages and benefits, but we cannot award speculative wages or damages. So it's pretty limited in what we can award. So that's kind of everything we've got on wage claims. Are there any questions? I know we'll have a longer Q&A at the end, but any questions for wages before I move on deeply? Great. So unit again is going to be responsible for investigating discrimination, harassment, and retaliation in housing. So who's protected? Everyone's protected. Everyone has the right to fair housing. The federal law is the Federal Fair Housing Act of 1968, and that is enforced by the U.S. Office of Housing and Urban Development, which we HUD. Utah's law is the Utah Fair Housing Act, again, is what we enforce. We are what is known as a Fair Housing Assistance Program agency, and that means that we work with HUD, and housing complaints filed with us are actually dual filed, so it counts for a complaint under both Utah and federal law. Under the Fair Housing Acts, there is a statute of limitations, so you have to file a claim within time. For our division, you have to file within 180 days or about 6 months of the last discriminatory act. Under federal law, that's 1 year. You also have the option to file a civil action directly in court if you want to, and that has to be done within 2 years of the last date of discrimination. Our Fair Housing Acts cover dwellings, What is a dwelling? It is building, structure, or land that is intended, occupied as, or designed as a residence. So land that's intended for a residence to be built on it, structures that are intended for residences, anything like that is going to be covered by the acts. Under the Fair Housing Acts, there are protected classes. So the discrimination has to occur based on a protected those race, color, religion, sex, national disability, familial status, source of income, sexual orientation, and gender identity. Under the Federal Fair Housing Acts, that only includes through familial status, but the federal government interprets sex to include sexual orientation and gender identity. Utah's protected classes that are only protected under Utah's laws are source of income and gender identity. And then these are just some examples of what discrimination. So things like terminating a lease because of a protected class, initiating eviction proceedings, or not renewing a lease, increasing someone's rent, decreasing services that they are allowed to access, harassing a tenant, delaying or denying maintenance, charging additional fees, or refusing or denying insurance coverage. So on fair housing before we move on to employment. Great. So our employment unit is responsible for investigating discrimination, harassment, and retaliation in employment. So there's the Utah Anti-Discrimination Act that is Utah's state law on anti-discrimination in employment. Then there is also Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Age Discrimination in Employment Act, and again, we have a relationship with the EEOC, the Equal Employment Opportunity Commission, where charges filed with us, the majority of those charges are going to be dual filed with the EEOC. So again, that means our investigation is going to count both for the state and for the federal government. Yes. So the underlying claim, there are a few kind of similar to the federal and state fair housing acts. There are some protected classes that are only in Utah. So if they are alleging one of those, it would be only filed under Utah's Anti-Discrimination Act. And then there are a few like Equal Payment Act, Wages Act. The EEO always get those. We don't have those. Yes.
Filing a claim federally, it's going to also be filed in Utah.
So it can kind of depend. It depends on if they file within our jurisdiction or not with the EEOC. So if they file with the EEOC within 180 days, I believe the EEOC can send those charges to us. Most of the time, if people are filing with the EEOC, it's because they're outside of our jurisdiction anyway, and then it would just be EEOC. So that to the statute of limitations that's at the bottom here. Our division only has jurisdiction over claims within 180 days of the last discriminatory act. So again, that's around 6 months. If it's between 180 days and 300 days, then even if they file with us, we actually waive those to the EEOC because we no longer have jurisdiction. Also have jurisdiction, an employer must have at least 15 employees, and those must be employer-employee relationships, not independent contractors. Again, similar to under the Wage Claim Act, we don't take the employer's designation as the end all. We do a further investigation into that to determine if they're actually employees or actually contractors. So essentially, what happened with our division? So first off, someone files a charge, and then we're going to look at that. Again, we may waive it to the EEOC if it's something like Equal Pay Act, or if it's outside of our jurisdiction, if it's between those 180 to 300 days. Then the E going to take over, and they're going to find cause, or they can issue a notice of right to sue. If it stays with us, we have an automatic voluntary mediation service. So every charge filed automatically set it up for mediation, but the parties can choose to not participate if they want. We have a great mediation unit who's highly successful in helping people resolve their cases. So a good portion does actually get resolved in that mediation stage. If they do not mediate, or if they're unsuccessful at reaching a settlement, then to the investigation stage. So the investigation stage is when our investigators gather the evidence, interviews, try to determine what happened and reach a determination. At that investigation stage, they can issue a no cause determination, which means there's no cause to believe that discrimination occurred. If that happens, the party can either appeal it or not. If they don't appeal it, that's the end of it. If they appeal it, they can appeal to the adjudication board, or they can remove the right to sue and go into court. If cause, same thing, parties can still appeal it and follow that same process, or they can request what's known as a substantial weight review, where they ask the EEOC to review the investigation and make a second determination to see if they agree with our findings or not. Yes. Currently, so the question was, what are the qualifications for our investigators? Currently, all of our investigators have JDs. A good portion of them are licensed attorneys. Some are active, some aren't. So that's a preference. But currently, all of us have at least that JD. So we have law degrees. Aside from that, it kind of depends on what everyone's experience. I know we've had some court clerks. We have an individual who retired from military service as a JAG attorney, and then I can't remember her position after that. We have highly qualified investigators.
And when there's a decision made at the investigation level and there is an appeal, what is the weight given investigators?
It's going to depend way they appeal. So if they appeal through adjudication, that is given to our decision. I'm hoping I remember this correctly. If they ask for the substantial weight review, that's in its name, they'll give substantial weight to our findings in our investigation under the EEOC.
Or if they get a right to sue letter,
then they're going to go to court, and it's a whole new ballgame. It's at that point.
Thank you.
Yep. And then also, just at any time in our process, parties can request to mediate. So even if it's in the investigation stage, they can ask to go back to the settlement table, or they can request a notice of right to sue and just go directly to court. They don't have to wait for our investigation to be completed. So this is some statistical data for fiscal year 2022. In that year, we had 532 employment cases filed with us. The 23% of them were mediated within our mediation process, and then approximately 5 mediated outside of our process. So they met and mediated separately, came to a settlement, and let us know. That went to investigation. About 6% of those end up being cause, and then 45% are no cause. Excuse me, that's of our total amount. I apologize. So of those 532, 45% were found to be no cause. And then we close 91% of our cases within 100 days. Keep in mind that 9% is most often because of our cause cases. So after we have a cause finding, we give the parties another opportunity to try to mediate. And so because it's still considered open past that, that can skew that length of time. For our cases, protected class that we get filed under is sex, followed closely by retaliation and disability. If you're looking at these numbers and going, wow, that is way more than 532, you are correct. It's because people can file and check more than one protected class, and often do. I would say the majority of our charges have at least protected classes checked. So that's why there's significantly more than 532. So in our division, our most charges that we see are disparate treatment, reasonable accommodation, harassment, and retaliation. Go briefly through what all of those mean to give you a better understanding of what's covered under our laws. First off, disparate treatment. There are 4 elements that someone needs to prove they've been subjected to disparate treatment. Disparate treatment is your classic discrimination. I was treated differently because of my protected class. So first, they have to prove protected class. Everyone protected number of at least one, right? Everyone's a member of like at least 3, but I digress. Second is that they have to show that they were qualified for the position. Third is that they suffered an adverse action, and fourth is that they were subjected to an inference of discrimination. So, protected classes under the employment laws are color, race, religion, sex, national origin, age, disability, pregnancy, sexual orientation, gender identity, religious liberty, and there's actually one more that just got added maybe a month ago on vaccine status or immunity passport is a new protected class, and I apologize, I forgot to add that on here. So similar to the Fair Housing Act under the federal statutes, only color, race, religion, sex, national origin, age, disability, and pregnancy are protected classes, but again, the federal government is going to interpret sex to include sexual orientation and identity. So liberty, it's not just about religion, it is actually about expression of religious and moral beliefs in the workplace, or religious, personal, moral, or political beliefs outside of the workplace. Where we see that most often, social media. So people posting on social media, it gets back to their employer fires them, puts them on probation, etc., may and likely is protected under this statute. Yes, question in the back.
The political expression?
Yes, under the religious liberty, it protects political expression outside of the workplace.
The employer, so to say, I work for, and here's my view.
So it can depend. So this statute is going to protect of those. If they are making it sound like it is the employer's position, then the employer has the ability to say, look, here is how this is impacting our business. So it's going to protect that expression, but under that statute, if the employer can show, let me try to remember the exact language. If the employer can show essentially that there is an undue burden on their business because of that speech, if they can show that it's actually impacting their business, then they can do something about it. What this really protects is employees, going on social express views and it not impact us. A business can't take employment actions against someone just because they expressed a view that the employer doesn't like. And then vaccine status and immunity passport is going to protect someone's either record of having a vaccine or an illness or not having one. It's only been out a month. We have assistance on it, so I can't really expand much more on that. Just know that it is a protected class at this point.
Is that federal or state?
That-
State.
That is state. Yep. So with those, with religious liberty and the vaccine status and immunity passport, those are state-only claims. So if someone were to file those would not be dual filed with the EEOC.
On the religious liberty, how important is it for employers to train on these things as well as the rest of these protections?
So the religious these ones been around only, I believe, 2016. So it's relatively new in the scheme of laws. Employers actually don't even realize that it is a protected class. I think it's important for everyone to know what their rights and responsibilities are under the law. So ideally, you should be training your employees about that as well. Yes. So inside the workplace, it's going to protect religious and moral expressions as long as they are seen and not interfering with the business. Basically reasonable. And as long as that type of expression is being allowed by others. So if an employer were allowing, I'm trying to think of an example of inside the workplace. If an employer allowed people to talk about certain religious belief, disagreed with only one religion and told that person, sorry, you can't that here, but they're allowing it in other respects, that's kind of where this would come into play. So it's more restricted inside the workplace, outside of the workplace, broader. Yep. So that's our first element, is that protected class. Second element is that someone is qualified. So for someone to be qualified, if they are a job interview, we are going to prove that the employer found them to be qualified for that job. People generally don't interview someone they don't think is going to be qualified for the job, right? If it is extended, they're also going to be considered qualified. If they work, they are considered qualified. Okay, this is a very, very low bar. It's pretty hard to say someone's not qualified if they've worked for you in the position. Even if later on you find out this person is competent, you hired them, they're going to be considered qualified. Our third element is an adverse action. I like to think of this as the bad thing, right? What bad thing is it that the person's complaining about? Were they terminated? Were they placed on a performance improvement plan? Were they subjected to an unpaid suspension, et cetera? What is it they're complaining about? So under these laws, cannot subject employees to adverse actions because of their protected classes. That's essentially what this means. And then our last element is an inference of discrimination. So how are you going to prove that your protected class was actually what caused that adverse action, that bad thing to happen? When we're trying to decide that, we're going to mainly look first at similarly situated individuals. What that means is other employees who have the same supervisor, who have the same work standards, and who engaged in similar conduct under similar circumstances. So if you have an employee who is 5 minutes late every single day, who you never discipline, and you suddenly have another who's late once, 5 minutes, and you're disciplining them, there's a discrepancy there, right? Why never subjected to discipline when this person was? Another thing we are going to look at, if it's going to show up, there we go, is if there is actual motivation. So are there texts, are there emails, are there recordings of the employer saying, the reason we fired you is because of your protected class? You would think this doesn't happen, but it does. I have legitimately seen someone say, so sorry, you can't work here anymore because you're pregnant and we don't think you can do this job anymore. In writing. You know, at that point, we don't need to look to similar individuals because they told us why they did it. Those are on the more rare side, but it happens. So an employee is able to show all four of these elements. They've shown they're part of a protected class. They've shown they're qualified. They've shown they were subjected to an adverse action, and they've shown, look, I was treated differently than someone else, or here's that, not the actual motivation, there's no burden shifting. So if they show these similar employees did similar things, but they were treated differently, that's their prima facie case. At that point, we're going to go to the employer, and it's the employer's turn to say, no, here's my legitimate reason for why I made that choice and I did that adverse action. So the employer has to show that they have a legitimate, non-discriminatory reason for its actions. This could be, look, this person was on a performance improvement plan, and they don't know that people were actually also on performance improvement plans. And, this is their turn to explain why they did what they did. If we have that actual motivation, they can't burden shift. You can't undo that. Or if their articulated reason is not credible. So how we determine credibility is there shifting reasons. Did they tell us first that the reason hired was because of performance, and then later because of attendance, and then later they said the person quit, right? If their reasons aren't even staying the same, that's going to lose credibility. Or if they have otherwise not been forthcoming in our investigation and they're losing that credibility. With pregnancy discrimination specifically, it's good to know that it includes both pregnancy and childbirth or related medical conditions. So it's not just pregnant, it's through that first year after pregnancy as well. So they are entitled to reasonable extra breaks, and they do not have to provide medical documentation for that. And they need to be accommodations for breastfeeding and other related conditions. Another, as you might remember, disability is a large portion of the cases that we get, and usually that is reasonable accommodation requests. So under the Americans with Disabilities Act, there are three definitions for disability. First, that's individual is substantially limited in your life activities because of a physical or mental impairment. Second is that they are disabled, so they don't have a disability, but the employer perceives them as having one. And third is that they are affiliated with an individual who is disabled. Under the Utah Anti-Discrimination Act, we do not cover affiliated with an individual. So if we get any charges like that, those are waived to the EEOC, and the EEOC will. Questions on, I'm getting some faces. Yes. So the question is what perceived as disabled. So this would be someone who truly does not have a disability, but the employer makes comments about them having a disability or being unable to do their job because of this supposed disability that the person doesn't actually have. So they're being treated as if they are disabled, even though they are not. Oh, another question.
The third one is affiliated. A person in the workplace has to take time off and do other things because they are a caregiver for somebody with a disability, or how does that work?
So it could be a caregiver, could just be that, for example, a spouse has a disability that the employer is aware of, and then the employer starts treating the employee differently. So it's that, again, the employee isn't the disabled one, but their spouse or family member, someone they're really closely related or associated with has a disability, and then starts treating them with that association. So along with disability, we have failure to accommodate. This is a big portion of the charges that we see, especially when disability is involved. So again, 4 elements that need to be proven are first, that they have a disability. Second is that they're qualified for the position with or without a reasonable accommodation. Third, that they requested a plausibly reasonable accommodation. And fourth, that the employer refused to accommodate. So when an employee will accommodation, they're going to go through what's called the interactive process, which you may or may not know about or be involved in. First off, the employee has to ask. We do not expect employers to magically know that someone needs a reasonable accommodation, right? You can't read people's minds. That would be kind of ridiculous to expect. So the employee has to ask, and by doing so, they have to reasonably inform that need. It can be made at the application process. It can be made 10 years into their employment. Anytime. There's no limit on when a person can ask for reasonable accommodation. It does not need to be in writing, and they do not need to use any magic words like I am requesting a reasonable accommodation. They just have to convey that they need a change. They need something different about their job because of their right. They're starting to convey I'm struggling with this. It needs to be a little bit more than I'm struggling with this, but they need to convey that they need a change because of their disability. And both parties are going to have a duty to engage in good faith. The employer receiving that request should engage in that informal process to clarify the needs so they can ask additional questions. Okay, you're saying you're struggling with this, what changed because of that, for more information. You can also ask for medical documentation to support the reasonable accommodation request, but you can only ask for medical documentation regarding the disability they are specifically asking the reasonable accommodation request for. So if a person has 5 disabilities, but they're only asking for an accommodation because of one of them, you can't ask for their entire medical file. You can only ask for medical documentation supporting that reasonable accommodation request for that disability. I like to think of this as a chain. Don't let the ball end in your court, right? If you have a request, you need to respond. If they never respond to your questions, if they don't provide you that reasonably requested medical documentation, they're the breakdown in the process. They're going to be the reason they didn't get a reasonable accommodation. If you don't respond as the employer, you're going to be that breakdown, and you're likely going to be found liable.
I had one question, a clerk online it talked about grooming, and the question said, Mike, help me if I get it wrong.
I would say generally yes. Right. I have never seen a reasonable accommodation request in regards to grooming, so I can't speculate more than that. On the disability definition, grooming is one of the things that so that's a major life activity. So when we're talking about disability, again, it's actually a low bar to show that a disability is needed. It just has to be a major life activity that can include grooming, breathing, peeing, liver function, kidney function, ability to process insulin, right? Non-visible things as well as visible things. So that's what the grooming was referring to in that slide. If someone is unable to do that and they request a reasonable accommodation, then you would need to go through that interactive process to determine what that reasonable accommodation would look like for that employee. So these are, try to go through these quickly. These are some examples of reasonable accommodations that someone might ask for, or that would generally be considered doable for an employer to do. And then with reasonable accommodation requests, if an employer is going to deny it, they need to be able to show that they were subjected to an undue hardship. That means we're going to look at the nature and accommodation that impact overall financial resources and the type of operation of the covered entity. So this is not just, oh, I don't want to spend a couple $100s for that reasonable accommodation. It's really got to impact and be something that would be pretty impossible, or if it's going to shut down your business, we don't expect you to pay for that. But if you're a large corporation versus a small one, that's going to change what you can actually afford. So come into play when looking at these as well. So harassment, employment is going to be unwelcome and unwanted conduct based on one or more protected classes. that is severe or pervasive enough to alter the terms and conditions of employment. So that unwelcome and unwanted conduct is our first element. That is subjective. It is based specifically on the person who's saying that they are being harassed. We don't look to if other people would consider it harassing. We don't look to if other people would think it was unwelcome or unwanted. Just them. If they say an unwanted, that's enough. Has to be based on. So if I don't like my coworkers making fun of my purple hair, sorry, not a protected class, right? It's got to be one of those sex, religion, national origin, race, all those protected classes we covered before. It also has to be severe or pervasive enough. So you want to think of this as a spectrum. You've got severe on one end, pervasive on the other. If something severe, you're to need less instances of it to be considered enough to the conditions of employment. If it's not very severe, you're going to need more instances of it to reach that threshold of creating a hostile work environment. Most of the time, we're going to see these somewhere in the middle. Severe examples are racial epithets, actual sexually inappropriate, right? Those are going to be on the severe end. Pervasive are going to be like pet names, like things that just once or twice are not going to be that big of a deal, but if it's occurring constantly, that could eventually become a hostile work environment. So with this, employers, if the harassment occurs with a worker or a third party, then the employer is going to have to either know or should have known about the harassment. If they did not, the employer cannot be at risk because they didn't know. Again, we don't expect you to read minds and know about things that you shouldn't. If they did know about it, then we're going to ask, did they take immediate and appropriate corrective action? Not everything requires termination, right? That's why it's appropriate corrective action. Did you respond? Did you try to stop the harassment and stop it from happening in the future? If that by a supervisor, then we're going to jump to did the employer take immediate and appropriate corrective action, because the supervisor is going to be considered, speaking for the company essentially. So train your supervisors. If you don't do anything when your supervisors are harassing people, then you can be at risk of being liable. And then our last charge that we see is retaliation. So for retaliation, there are 3 elements. First, that someone engaged in protected activity. Second, that they were subjected to an adverse employment action. And third, that there's a causal connection between that protected activity and the adverse employment action. So under our statutes, protected activity is one of, think of them as 3 things. We've got 4 bullet points here. Complaining of discrimination. So that's going to their employer. I feel like they did against or harassed or retaliated against. They're raising that complaint. Participating in a formal complaint process. So that's either with our division, the EEOC, or the employer's process. Opposing discrimination. So maybe it's not happening to them, but they see it happening to a coworker. Again, that's that complaint of, hey, I think this is wrong and it's happening to someone else. That's still protected activity as long as it's a reasonable belief and in a reasonable manner. Or if they request a reasonable accommodation, the 10th Circuit has considered that protected activity. So if someone does any of these things and then they are subjected to an adverse action, again, these are those bad things they're complaining about. If they're subjected to action within 3 months, it's going to be presumed to be retaliation. And then the employer is going to have that opportunity again to explain why they did what they did, provide a retaliatory reason for their decision. Retaliation also is broader than discrimination in that it can include both work-related and non-work-related actions. Discrimination has to be work-related adverse actions. And then that last element is that there is a causal connection. So suspicious timing, if someone completion and you fire them the next, it's pretty suspicious timing, right? If there are false statements, and then again, we're going to look at comparative evidence. Those similarly situated individuals, were they behaving in the same way overall? If the employer says someone was fired because of their attendance, has anyone else been fired for their attendance before? We're going to look to that evidence. Causal connection can be defeated. The employer was unaware of the privity, or if they permit non-retaliatory reason. So how be unaware? For example, someone may file a charge with us. Employers are not notified of that charge immediately from us, right? It takes a little bit of time through our process, not a ton, but there can be a week to 2 weeks before an employer is notified. So maybe someone filed a charge on June 1st and they're June 3rd, but the employer wasn't even aware of that charge until June 10th. Because they're not aware of it, possibly have retaliated against it. That's what that means. And then here is our contact information. So I know we went a little bit over, but we had some questions in the middle, so hopefully that's okay. Further questions? Okay.
First one from our online folks. What if there's a medical condition that isn't, but it may still require some kind of or may still require a request, a reasonable accommodation request?
So not every medical going to be a disability. So for example, like a cold or a flu, things that are temporary are not going to be considered disabilities. But that bar, sometimes those things could turn into a disability, right? If it's long lasting, there's this kind of gray area with, for example, broken bones or surgery that may not qualify as disability. So all of those are going to be looked at on a case-by-case basis. And I can't really say further than that if it would or would not be a disability, but best practice is generally just go through that interactive process for any requests like that.
Got another question we'll catch up on. We're going to go to one in the room and then we'll.
When you were talking about classes in the state of Utah, at the beginning you said that this didn't cover or have to do with government employees. Is that correct? All those protected classes, or
So
does
that was for the Utah payment.
okay? So that does include government employees. That state of Utah law, correct?
That is
Those-
my understanding.
Those protected classes.
Yes.
Or is it just the federal ones you had there?
Both.
Both.
If I'm understanding your
Because it's in
question
the state of
correctly.
Utah.
Right.
Yes.
Okay, we had multiple questions about this child labor questions.
Okay.
And I know you're waiting for those. And I just figured I'd kind of summarize those things because we have multiple questions all the time about these. What can 15-year-olds do, 16, 17? Can they drive? We talk about lawnmowers. Well, can they go out on the golf course and operate an industrial type lawnmower if they're 16 years old? And I know that's throwing you a whole bunch of stuff, but there are a lot of questions that we get on a fairly regular basis, and because of the challenges that we're currently having with labor force, a lot of members of the trust, local government agencies out there are looking to other hiring pools. Hey, we got some teenage people out there who could fit into that category. What can they do? So I made it a long question to let you give you time.
All right. I appreciate it. So we have this of things they definitely can do earlier in the slides, and feel free, you can share these slides with everyone if they'd like. Other than that, I would look directly to the Utah Employment of Minors Act, because it does list out things that they can specifically do and at what ages. Really, and so it's really going to depend on exactly how it is and what job you're wanting them to do. That's kind of the best I can answer that. I'm sorry, it's not more detailed.
That's great. And just from the trust angle on these things, we always look at, law is important, but the spirit of the law, if I'm putting a child, teenager in a dangerous situation, we don't want some things. Some of those are specific on driving. Can a 16-year-old drive? Well, the short answer is no, but the long answer is sometimes. And so there are a few things on that. So.
Yeah, the seems to really stem from there in the code. It says that they can mow lawns, they can use lawnmowers, but it doesn't say a push lawnmower or a ride lawnmower or an industrial lawnmower versus residential lawnmower. And I think that's where a lot of the confusion is coming in. Is there's some ambiguity there in the code, and they're just wondering how they can be protected, what they should be telling.
I am not positive, so I apologize.
So I'll fill in on that just from a trust standpoint. Think about that. If it looks like a duck, if it looks like a heavy equipment, we don't want kids on heavy equipment. I hope that.
Right, because they again, minors can't be employed in hazardous occupation. It's really a pretty good act specific on what minor to do for if it's gonna be considered hazardous or not.
A recommendation would also be to look at the manufacturer's information on that piece of equipment. It may have that specifically on there. And then a question, can an employer just call the division with questions like
You can, whether or not it depends on if it's asking for legal advice, but yeah, you're always more than welcome to reach out to us, and I can ask and follow up with you, Jason, on the lawnmowers. I just haven't seen that either way, so I'm not sure that's something we've even had to consider so far. But I'll ask and see if there has been anything on that.
My question relates to wage and hour. From time to time, we have employees that want to switch a shift within a 40-hour work week. We've tried to look into the scenarios where we could switch shifts outside of a 40-hour work week, and this is an hourly wage employee. The standard answer that I've been told is that anything over 40 hours, I have to pay overtime. I know within healthcare, law enforcement, things like that, that there are opportunities where they're able to switch shifts. This is documented, company-wide. Is there any additional information on that or anywhere that I could look on that subject?
So overtime is actually governed by the Fair Labor Standards Act, which we don't enforce. So I can't provide additional information about what your rights would be under that federal law because we don't do it.
Okay, thank you.
Okay, so I thought you had a slide that said that 16 if they have a license, they can drive.
Mhm.
I would just say here's my answer on that. Mike is actually sending out a link to a webinar we did on this subject, and every year springtime we get a lot of questions on this, and so it's on our YouTube channel. Mike's sending the link out for everybody that's here live. We'll email that out to everybody here. That one's it's a little tricky. There was a question online as well about golf carts, and it specifically calls out golf carts and says they can't drive golf carts. But if you read a little deeper, it's if they are crossing a road, a public roadway. I was trying to remember the exact language it uses. And you think about most golf courses. Well, if you're going front nine to back nine, you're probably crossing a public roadway. And so anyway, just to move that conversation along, we go into a lot of detail in that webinar, and so we'll send that link out so everybody can look at that. It's certainly a challenge, and we're happy to walk through it with you as well.
Well, and on that note, what we covered is the state's laws, unless we did, the EEOC where we dual file and we have a little bit more jurisdiction over that. But the state's laws may be, this level. Federal laws may have greater restrictions. So that's another thing to look into is there may be additional responsibilities or requirements federally that aren't necessarily state enforced, but you could still be liable for it for breaking. Any other questions?
Get them all online, Mike. That's it.
All right, great. Well, thank you everyone for having me. I appreciate it, audience.